Appeals. We have two cases on our 130 docket. Both are Kazazian versus GHP Horwath PC. The first case, I believe, is the summary judgment ruling. The second is the attorney fees ruling. Counsel are both present. Have you have a chance to pick up the oral argument procedures and review them?
Yes, Your Honor.
Yes.
Thank you. Thank you. Do you have any questions about them?
No.
Okay.
No, Your Honor.
Okay. Before we begin, I'd like to remind council that, we're being live streamed and we're also being recorded on our website. We would therefore be very careful and conscious of sensitive information. I don't believe there are sex assault victims or juveniles in these cases. But if it's sensitive information, please don't disclose it. When you come to the podium, please give us your name and attorney registration number. Everybody in the audience, please turn off your cell phones and pagers so as not to disrupt the oral arguments in this case. And finally, the last thing I want to say with respect to the first two cases, I realize that in the trial court and also in the briefs, the cases generated some heat between counsel. I want counsel to remember and remain professional and civil at all times today. Got it? Okay. I think with that, because we're not going to tolerate incivility or unprofessionalism. Okay, with that, I think we can begin the first argument.
Good afternoon, Your Honors. I'd like to reserve 5 minutes for rebuttal.
You will be in charge of your own destiny, counsel.
Okay, thank you. May it please the court, my name is Nina Kazazian. My attorney registration number is 21910. Regarding the first case today, which is case number 17CA0609, I have two issues, 2 points basically to make. The district court misapplied the standard of review when evaluating summary judgment by making determinations of fact, which resolved what were otherwise disputed material facts upon which the court entered judgment. And the second point is that the court should not have awarded costs that were not necessarily incurred, and also because summary judgment was improperly entered, I believe that the award of attorney's fees and costs should be reversed, but those arguments will be made in the second case.
That's right. Thank you.
So, first of all, the court misapplied the standard of review because there were material facts in dispute. The appellant incorrectly asserted in his answer brief that there was no evidence. I would point the court to the record in the case with the affidavits that I submitted in support of the motion for my motion for summary judgment and in response to the appellant's. That is in the 17CA1939 record. It's CF 42 to 51. I'm sorry that something happened to my computer and I don't have the record that was designated for this case. It somehow has disappeared. So with the court's permission, I would refer to the references in the brief, and in today's argument, we'll probably be using the 1939 record. So the primary question is whether there was a contract formed, and under Yackel versus Andrews, 195 P3rd 1101, specifically 1111 to 1112. The plaintiff's email assent, which was delivered in the morning of May 20th, is sufficient to form a binding agreement. Whatever happened after that point doesn't negate that.
Ms. Kazazian, do you agree that under the terms of the offer you received, you were required to send the signed settlement documents to GHP by mid-morning before noon on May 20th?
Actually, Your Honor, that's an excellent question. No, I don't agree with that, and I'll tell you why. Because although the original offer specifically said you must return the agreement, On May 20th, the emails that are interchanged between the parties do not say that. The emails I wrote says, you know, will you agree to this? The defendant's response is the important part, and that says, and that is on page, sorry, it's in the record on page CF 264 to 266. The defendant's response was, my client accepts your proposal, comma, but we would like the agreement by midday.
Does it
Yes.
say we would like it or
No,
we need it?
We need it.
We
Yes,
need it.
I believe that's the correct language. I'm sorry, I misquoted that. However, I would argue to the court that if the court, first of all, what we're doing right now is making an interpretation of what the intents were of the parties. That is precisely the sort of thing that a court may not do on summary judgment.
Well, may not do if the intent is in any way ambiguous. If the intent appears to be clear from the language, courts have granted summary judgment before.
Okay, understood, but I would argue in this case the intent is not clear, because if the defendants had intended at that point that delivery of the signed agreement by a certain time was the only way the agreement would be formed, then they should have said that. Mr. Bone is an attorney. He's been practicing longer than I have. And if Mr. Bone intended for, at that point, that the written agreement needed to be returned in order for there to be a binding settlement, then he should have said, we agree to that on the condition that you provide it.
How about we need the signed documents as you have indicated, i.e. mid-morning before noon?
Okay, Your Honor,
Why is that not the same effect?
because it's not the same words, and you cannot interpret things differently. You have to interpret the plain words, not provide additional meaning.
Don't the plain words mean that you had to return the signed documents by mid-morning before noon on that date? What's ambiguous about that?
Well, Your Honor, there is nothing in the agreement and there's, Your Honor, all I can tell you is that at that point, that was not the understanding. There was explicit language previously that was not carried through to the last, essentially, on midnight of that day, or just after midnight. Essentially, that's when I said, you know, it wasn't returned by midnight. That was the offer.
Ms. Kazazian, did you submit your own proposal later on May 20th?
Yes, Your Honor, I did, and I would, as I said.
So why would you do that? I mean, that.
Well, Your Honor,
Is
I
the-
believe I explained that in the district court and in my affidavit. The basis for that is if you look at the language of the settlement agreement that was solely drafted by the defendants and is appended as Exhibit A and B to my affidavit in support, and that's at the court record, court file 44 to 51 for 1939. I referenced it also in my brief. That settlement agreement doesn't negate a hearing. It's crazy, I agree, but that's not what the language says. The language of the contract, drafted by an attorney, says this agreement will be effective upon the plaintiff's acceptance of the payment, and the payment terms said that the payment would not be provided until 10 days after signature. 10 days after signature on May 20th was May 31st. That would have been more than a week after the hearing took place.
Well, let me ask, is a counteroffer understood as a rejection of an offer?
Well, under that principle, I'm not disputing.
That's not.
Yeah, I'm not disputing that point of law, of course, but I am disputing that that's what happened on the afternoon of May 20th.
So,
because,
well, let me just
Okay.
slow you down. Because
sorry, I know, I'm always
the
conscious
judge-
of the time limit.
Well, the judge made some fairly detailed, what appear to be undisputed facts with respect to later on May 20th at 1:08, plaintiff emailed defense counsel with her own proposal, and he goes on. And that's materially different than anything before. So this appears to be just a standard counteroffer.
Sure.
And the law seems fairly settled on this.
By that perspective, I'm not going to dispute that, Your Honor, but that's not what the facts in this case actually reveal. The facts in this case under existing Colorado Supreme Court law, in particular the Yackel v. Andrews, would indicate that a settlement agreement can be formed without having a signed agreement. And the fact that I said, I'll take your proposal and
But slow down
Okay.
again. I'm trying to figure out, you made a counter offer.
But
So there may be dispute about what led up to that, but you clearly made a counter offer.
Well, Your Honor, the part that I'm disputing is that once an offer is made, and if there's an offer and acceptance, a contract is formed. And after that point is when I looked closer at the agreement and I said, this is crazy. This doesn't get rid of the need for a hearing. In every experience, you do a settlement offer so that you don't have to have a hearing. But that's not what this said.
If you could help me understand, in paragraph 8 of the unsworn foreign declaration you submitted in the district court, you said later that day, which is May 20th, and over the weekend, after I expressly accepted the agreement, I tried to communicate with Mr. Bone to renegotiate the agreement.
Right.
If the agreement had been accepted and there was a contract formed, how could it have been renegotiated subsequently?
Well, that would have been, a renegotiation is different than a counteroffer, as I understand it, because what I was trying to communicate is one of the big problems in this case, there's several, but one of them is that there have been points in time when I don't really understand what Mr. Bone is trying to do, or whether that's if he intends what he drafted. And when on the afternoon of May 20th, I'm looking at this, I'm like, wait a minute, this is a little nuts. We're still going to go to the hearing because this waiver doesn't include a waiver of their claims for attorney's fees. It's not effective until after the hearing. That seems crazy. It would seem to me that if that's his intent, then I should know that. If it's not his intent, any reasonable attorney would allow a conversation to say, oh, yes. And I tried multiple times to contact Mr. Bone.
Can you secretly assent to an offer?
No, but by email was the assent.
No, you didn't assent. You didn't send that assent until after you had proposed your own counteroffer. You didn't actually show an assent or manifest an assent to the other party until actually after the hearing.
I would disagree with that, Your Honor. I would say that the email that was sent on the morning of May 20th was the assent.
And
under Yackel, that would be binding. If the situation were turned here, Mr. Bone would be arguing that I indicated by email that I was taking the deal and that there was, nothing left to dispute on the contract. And Your Honors, I believe that what's happening here is your interpretation. I understand your interpretation of emails, but emails are not, as far as my intent is not necessarily that emails provide every last detail of every thought. In fact, they're short. And
I'm still trying to understand your statement in paragraph 8 of the affidavit.
Yes.
So in there, you said you accepted the agreement on the 20th.
yes,
You then went to a court hearing
Yes.
without telling the court that there was an agreement in place.
Your Honor, I know it sounds crazy, but look at the language of the settlement agreement. The settlement agreement says it's not effective until after the payment is received.
But wasn't the purpose of the agreement to avoid having to go to court?
Well, you would assume that, but all I can do when I tried to call Mr. Bone, I contacted his partner. I'm like, this stuff doesn't make sense. We need to talk about this on Friday. I got no response. I tried to talk to him in the morning on
Did you
Monday.
ask for a continuance of the hearing at the beginning of the hearing? Did you stand up and tell the court, I think we have an agreement, let's put this off?
Well, no, I didn't, Your Honor. And part of that, look, all I can tell you is that the course of history on this with this individual has basically had me, I'm sorry, terrorized, and as a pro se plaintiff, not in the same space, but when Mr. Bone didn't say anything and wouldn't talk to me, I assumed that he intended that the language as written meant that the hearing was supposed to go forward. His claims were not,
And what about your language as written? It's not binding on you?
what do you mean?
Well, the emails that you sent, such as kind of like, I have issues with the documents you sent yesterday afternoon. And
Yes.
the terms, which are not acceptable. According to you, you had accepted those terms.
Well, yes, Your Honor, so, you know, that's a different,
You had secretly accepted those
no, I
terms?
had expressly accepted by email the terms with the formal writing to follow. That's exactly what happened in Yakel. And because the terms, if the terms of the agreement were different, but the court and this panel respectfully is interpreting the contract with meaning that are not contained in the plain language of the contract. The interpretation of the plain language of the contract says that if the agreement isn't effective until the payment is received 10 days later.
And we might be interpreting the offer and the supposed acceptance or lack of acceptance to the agreement, because those terms are in writing as well.
Yeah, Your Honor, I would submit that under Yakel and the Colorado Supreme Court law following that case, that the written assent is sufficient to create a binding agreement. And I have 42 seconds left. I'd like to reserve the rest for rebuttal if the court will permit it.
Thank you.
Thank you.
Good afternoon, Your Honors. Michael Bone, B-O-H-N, with Bone Aguilar LLC, registration number 18716, appearing on behalf of Appellees GHP Horwath PC and Nadine Petrowski. I understand that Ms. Petrowski was dismissed from this case during its pendency, but obviously she's still a named party in the upcoming oral argument in case number 17CA1939. Your Honors, let me just start with this. The email communications were very clear in this case. We were attempting to resolve the underlying small claims litigation with Ms. Kazazian. I wrote her an email on May 19th at 6:34 in the morning, and I made expressly clear, it was actually 6:42, my apologies, I misspoke. Nina, GHP has authorized me to make a one-time settlement proposal which is memorialized in the attached settlement agreement and mutual release. It is non-negotiable. If you accept the terms of the proposal, please execute the agreement in the presence of a notary and send me a copy via email no later than midnight tonight in bold types, and provide to me an original signed document by U.S. mail. Please also execute the stipulation for dismissal and send me a copy via email no later than midnight tonight. I will hold the stipulation in trust until you verify receipt and clearance of the settlement funds. Once I receive your verification, I will file the stipulation. That was sent on May 19th, 4 days in advance of the hearing that was coming up. Ms. Kazazian asked for the signature. You all have read the record, I'm sure. Ms. Kazazian said, I need the signature to know this is a valid offer. It was a valid offer, but I contacted my client. I said, put your signature on the document. I don't see any problem with that. We'll send it to Ms. Kazazian. We did. Before I did that, though, Ms. Kazazian said, I don't have an answer yet, and this email is in the record. And so I sent that to Ms. Kazazian. I told her the deadline for your acceptance remains midnight tonight. No other terms were changed in my original email. Again, we'd not heard any acceptance of the settlement offer, but instead at 12:57 a.m. on May 20th, after the offer had expired, I get an email at 12:57 a.m. on May 20th. If you tell me you'll still honor this, I can sign it before a notary and return it to you by email with original to follow by mail. Obviously, she's following the protocol that I had outlined in my original email, recognizing that that's how the offer would have to be accepted. Please call to confirm. Instead, I wrote her an email. Nina, my client has agreed to your proposal, but we need the signed document as you have indicated, i.e., mid-morning before noon. Again, we did not receive any information, and instead, at 11:27 a.m., approximately 30 minutes before the deadline was expiring, Ms. Kazazian writes, "I still have not heard from you. I have issues with the documents you sent yesterday out of the blue and the terms in those which are not acceptable. If you want to resolve this, you will need to call me. The hearing is still on for Monday." Those are her own words. Implied in that statement is she knows had she accepted the settlement terms, there would not be any need for a hearing. Lest there be any doubt, look at the documents that I sent with my email communications. It was a broad form comprehensive settlement agreement. We wanted to end this litigation with Ms. Kazazian. We were willing to pay her, my client was willing to pay her $10,000 to resolve any outstanding dispute with her. And keep in mind that that settlement offer of $10,000 was $2,500 more than the jurisdictional limits of the small claims court. We wanted to be done, right? Instead of Ms. Kazazian accepting that and sending the agreement signed as we have requested, she specifically said it was not acceptable, and I'll see you in court on Monday. We all know what that means, Your Honors. That was not accepted. And later that after the offer had then expired at 1:08 on May 20th, approximately 1.5 hours after she had already rejected our offer, she says, "I've got my own way of resolving this. Here is the counter offer," as Your Honor had pointed out here. That was a counter offer. She rejected our offer. She made her own offer. And that was not accepted by GHP. So we went to court on that following Monday, May 23rd, and had a hearing. After that hearing had concluded, within an hour, Ms. Kazazian sent me an email saying, "Oh, I've accepted your offer. I signed it before noon last Friday." That was not the terms of the offer. She knows that's not how this was going to go down. And her conduct after the events on Friday revealed and demonstrated to the trial court, as we had argued to the trial court, somebody that thought they had a settlement agreement would not have undertaken the course of conduct that Ms. Kazazian did. She's telling this court today that she assented to the terms of the agreement, even though there's been no evidence that she offered to the trial court, no evidence in the record whatsoever that she accepted the terms of our settlement agreement. Yet she's telling this court she assented to the terms of the settlement agreement. We know that's not true, because if she had assented or accepted the terms of the settlement, she would not have proceeded to the hearing on Monday.
Isn't there some evidence that she assented, perhaps untimely? Didn't she produce either an affidavit from a notary saying that, that she had signed an agreement at some point?
No, Your Honor. She just produced the notarized copy of the agreement, and as the trial court pointed out, there was no time stamp as to when it was actually executed. Not that that would make a hill of beans difference, Your
Okay.
Honor. I mean,
The one last thing I want
Sure.
to say is, I thought in her affidavit, she indicated that it had been signed that day, May 20th, whatever it was that we had the flurry of emails.
to tell you the truth, Your Honor, I don't recall specifically what she said, but I do recall if there was a statement about that, the time that that was supposedly executed was before that she had rejected the offer. So she basically told us, we're rejecting the offer. We have no terms of agreement. So she did just keep that signature in silence, supposedly. I mean, I have no way to verify whether the notary actually signed it that day or not, because we never needed to get that far, because there was no contract that was formed here. But where I was going with this, the rest of my argument here that I've outlined to the trial court, was that somebody who thought they had a settlement would not have gone to the hearing on Monday. When Judge Buchholz in the small claims court specifically asked Ms. Kazazian, do you have a settlement agreement? She said no.
Is that in the record? Do we have the transcript of that hearing?
There is an affidavit, I believe, signed by my client in support of that. But she did, what is in the record, what isn't in the record is her acceptance or her telling the judge, yes, by the way, we have a settlement agreement. We don't need to go forward today. She did not tell Judge Buchholz that she had a settlement agreement. And so she proceeded to hearing. and she endorsed exhibits the day before. She sent the counteroffer on that Friday, May 20th in the afternoon. Again, all these indications to suggest, I don't have an agreement with you. And very importantly, that the trial court didn't mention, I don't believe in His Honor's order granting summary judgment in our favor. There's one critical component here. Ms. Kazazian also appealed the small claims court decision on June 8th. So if she thought she had a settlement as of May 23rd, why in the world would she be appealing the small claims decision?
Is that in the record, counsel?
Yes, that is in the record.
Yeah, she filed a notice of appeal, but she didn't file any further documents in that appeal, did
She may not have filed any documents, but she did commence an appeal, and I believe at that point it may have been untimely, Your Honor. Oh, the other, GHP, obviously a judgment entered against GHP in the small claims court for the amount of $2,360. We immediately paid that, and Ms. Kazazian accepted that check. And so she knew at that point that she was accepting this check based on the judgment that was entered by the trial court in the small claims case, and therefore, if she would have had a settlement, there would have been no need to accept that judgment. There would have been no need to proceed to judgment, but instead she accepted that check, acknowledging that that was the judgment amount that was paid to her.
Did the 2360 include any kind of request for attorney fees or costs or anything like that?
It did, Your Honor. Let me explain how that went down.
You don't have to spend much time on that, counsel.
All right, it did. It was the judge awarded a little bit of fees to us, GHP, and awarded a few fees to Ms. Kazazian. The offset equated to approximately a $200 increase in the judgment that the small claims court had awarded Ms. Kazazian in the amount of $2,100. So it raised the award by $300. So long story short, Your Honors, Ms. Kazazian never came forward with any evidence in the trial court that she had accepted our settlement offer or any evidence that a binding settlement agreement had ever been reached. We tried, but we never formed a valid contract because Ms. Kazazian either let the offer expire, she affirmatively rejected it, or she made a counteroffer. Plain and simple, and the trial court did not err in any respect in granting summary judgment in our favor. Importantly, I want to point this out, Your Honors, I think we made it clear in the record, all of the evidence that was offered in support of our motion for summary judgment were the emails exchanged between myself and Ms. Kazazian. I endorsed those. You'll see the GHP stamp on the bottom as our Bates labeled. Ms. Kazazian never questioned the authenticity or admissibility of any of those documents. And if you look at the express, as you all have, if you look at the express language in those emails, it is very clear what we were requiring in terms of making the offer and what Ms. Kazazian needed to do to accept that offer. And if you look at the terms of our settlement agreement, of course it included the attorney's fees that both of us would have incurred at the fee hearing. We would have given up our right to argue for fees, and she was giving up her right to argue for fees. The settlement agreement was just like any other settlement agreement. We'll pay you in 10 days, but in the interim here, everything's done, and I'll hold in trust, just as I told her, I will hold in trust the stipulation till I make sure you get paid before I file that. As an officer of the court, I would not have filed that and did not file that if we would have had an agreement, but no agreement was ever reached. Instead, Ms. Kazazian filed this lawsuit, and in which I do want to point out, in her complaint that she filed under penalty of perjury in this case, she specifically alleged that she signed and delivered the document, acknowledging that she would have need to have delivered the document on May 20th. We now know in the undisputed evidence that that document was never delivered, but she knew she had to make that allegation in order to meet the terms of the offer and acceptance. So I would point out to Your Honors, if you specifically in her complaint, paragraph 8, that's what I thought it was, and I don't know exactly where in the record the complaint is. Actually, it's on page 1. How could I forget that? Page 1 of the record, paragraph 8, plaintiff executed the agreement and delivered it to defendants on May 20th. We now know from Ms. Kazazian's statements in her briefs and her statements here today and in her statements to the trial court in an attempt to oppose summary judgment, she never did deliver that agreement and no contract was formed. The decision of the trial court in granting summary judgment in our favor was exactly correct. Thank you, Your Honors.
Thank you, counsel.
Can I have a second?
You have 42 seconds. You have 38 seconds.
Can I have a second before I take my?
Yes, yeah, absolutely.
Thank you.
Absolutely.
All right, I'm going to try to make this quick. So first of all, defendants, appellees acknowledged that their offer had expired. So the offer that I made on the morning, they assume a whole bunch of terms about delivery and everything like that that were not included in that offer. And what's basically happened here with Mr. Bone's arguments is the same thing that happened in the district court. Mr. Bone is arguing the papers and not allowing the interpretation, making inferences, arguing inferences, and the district court made inferences and made those arguments. These are all things that should have been decided by a fact finder with live testimony to determine credibility, instead of making inferences to decide what the intent was of these documents.
Counsel, your time has expired.
I have 8 seconds.
You have 10 seconds over. Look at the red light.
I'm sorry.
No, that's okay. Thank you. Thank you, thank you, thank you. Let's take a half a minute and get ready for our second case. The case will stand submitted and opinion will issue in due course on this case. Counsel, when you're ready, we'll be ready to proceed on the second case here.
I have a procedural question. I've not been in a situation where there's a cross appeal.
Right?
So is it still that I start, yeah, I'm assuming I start because I have filed the appeal.
You do start.
Okay.
And it's your choice as to whether you want to use your time to address the cross appeal up front, or
Okay.
you want to reserve some time and perhaps address the cross appeal. You yourself have 15 minutes within which to respond and argue your cross appeal.
Okay,
Okay?
all right, thank you.
Go ahead.
Question from my perspective, Your Honor. Can I reserve any time for rebuttal?
No,
given that I'm a cross-appellant?
I'm sorry, believe it,
That's fine, I just didn't know.
believe it or not, we don't have the SIR rebuttals and things like that. But thank you.
Thank you.
Ms. Kazazian, are you ready to go forward?
Yes.
And we will hear the case of Kazazian versus JHP Hoarth on the attorney fees issue.
May it please the court, my name is Nina Kazazian. My attorney registration number is 21910, and I am here as the appellant pro se. On this appeal, 17CA1939, there are two issues. One is whether the court incorrectly interpreted CRS 13-17-102 to conclude that the action in the district court lacked substantial justification, such that an award of fees to the defendants was warranted. And then the second question is whether the court incorrectly applied the statute CRS 13-17-102 and controlling law regarding how to make determinations of reasonableness of the attorney's fees in making its award to the defendant. The answer to both of these questions, I submit, is that yes, the court erred in both respects. As the court noted in its December 29th, 2017 order, the Plaintiff, at that point appellant, did provide evidence within the hearing that the court found was reasonable as to why certain actions took place, why the case went forward in this small claims court to the hearing. And although the court used that evidence to deny the defendant's request for attorney's fees incurred in connection with the hearing, that evidence also supported a denial of the defendant's motion for fees in the first instance. On the first case, the record is rife with credible evidence as to why the actions were taken. Whether this court or the district court found those persuasive is not the standard that must be applied for 13-17-102. In re Shimizu indicates that the definition of credible is separated from whether or not it's persuasive. I maintain that my interpretation and my actions were made in good faith based on my reasonable interpretation of the language of the contract. And the lack of ability to clarify that with the defendant's counsel because he wouldn't talk to me. And the court correctly found that that was reasonable evidence in the context of the hearing. Now, in that hearing, all the issues were at play. It was not just how much the fees should be, but rightly whether fees should be assessed. My assertion is that once the court had determined that that evidence had been provided in that hearing that substantially justified the underlying action.
Counsel, I thought in your brief you argued that the court had denied you a hearing on whether fees were justified.
Well, Your Honor, I'm not sure. I do remember making that. It was unclear to me from the court's order whether it was going, at first the court said he wasn't going to, and then the court said all issues would be heard, and then the court said wasn't, but I argued it anyway. So are you withdrawing that particular issue from the appeal? You mean whether the court provided a hearing? Yes.
On that issue?
On that issue, yes.
Okay.
I'm withdrawing that, and I apologize. I think that was a mistake by my part. On the issue of delivery of the agreement, my counteroffer on the Friday, May 20th, did not say it was only going to be effective with delivery. Those may have been defendant's terms, but as defendants already acknowledged, that agreement had expired. Those terms no longer existed. So I used the mailbox rule. I signed it and I posted it. That is a valid method of delivery under basic contract law. And because there was no discussion and no renegotiation and no, as defendants already conceded, that the action wasn't dismissed until 10 days after the hearing or after assent, the hearing, from my interpretation, had to go forward. So
if I could address the mailbox rule point, didn't the communication from the defendant say, we need the signed documents, as you have indicated, i.e. mid-morning before noon. We need the signed documents, not you can put them in the mailbox by noon.
Well, Your Honor, I don't believe that, first of all, I have a lot of issues lately these days trying to figure out how we're supposed to, as a general rule, construe and interpret emails. There's clear rules on the interpretation of contract. There's clear rules on the interpretation of statutes. I don't believe, as far as I know, that there is a similar parallel for email communications. But my understanding of that was that if the defendant was making a contingent acceptance, that would have been made clear. You can say you don't agree with that interpretation, but I had a reasonable interpretation of that, and you can have different interpretations. Do you have a question?
I do have a question,
Okay, I
counsel.
didn't want to keep talking. You were nice not to interrupt me.
I can see where you could have a reasonable interpretation of an ambiguous offer acceptance like that. But if they're unambiguous, I'm not sure that a party gets to say, but I had a reasonable interpretation otherwise.
Well, okay, I just don't think it unambiguously said
Okay.
that it was conditioned, because in my view, if it wanted to be unambiguous, Mr. Bone is certainly expert enough in the law that he would have said, however, as he did previously, it must be returned to us by noon, bold, capitals, underlined. He didn't do that in the end. So if you look at the internal documents, there's an inconsistency, and therefore I don't think that it is fair and unambiguous to say that terms that were originally transmitted that had admittedly expired were then part of the discussions and agreement on the 20th of May. Okay, so with respect to the amount of attorney's fees, on the amount of attorney's fees, first of all, obviously, I don't think attorney's fees should have been assessed in this.
Before we get to the amount of attorney's fees, you argued that the trial court was required by statute to make certain findings and didn't do so. What findings do you contend the trial court failed to make as required under Section 103?
I don't believe that the court gave any consideration for the relative financial position of the parties. That is an important position. The court also did not give any consideration to whether the defendants had whether the total amount that the defendants were asking for was reasonable, and also the net effect of this attorney's fee award. I mean, as difficult as we all might like to think it is, but I seriously don't have, and it didn't at that point, have financial resources. I went through a terrible divorce several years ago, and it set me back in ways that were unimaginable. Did
you argue your financial condition at the
I
hearing?
absolutely did, and that is in the record. I'm sorry I don't have the pinpoint site for that, but I believe that was in the transcript of it was either the 17th or the 23rd of August.
Ms.
The two
Kazazian?
transcripts are in the record.
Sorry to interrupt.
No,
but,
please.
The judge on page 4 of a fairly lengthy order at D states the relative financial positions of the parties involved. Are you saying he didn't address it, or what is the error that you're saying?
Although the court listed that, in just a second, I'd like to take an opportunity to actually review that language again. You're saying on page 4, is that what you said, Your Honor? I'm sorry.
Yes.
Yeah, Your Honor, I would argue that the language here the requirement to consider the relative financial resources of the party, here it just says that the plaintiff should have been aware of the great deficiencies in her case. That's not even though the court led up with, gave evidence, the court doesn't really consider that evidence, and it didn't consider in the way that the statute requires the great wealth of GHP and the fact that Mr. Bone took no actions in this case that mitigated those, including making misrepresentations in his answer about the status of the parties.
Counsel?
Yes.
I thought the finding does say that you had some financial difficulties, but as an experienced attorney, you should have known you might have been getting into financial hot water with the positions you took.
Well, Your Honor, I do see I agree that obviously that it says that, but my understanding of the statute is that it is not intended to put somebody in bankruptcy, and that the chilling effect of essentially, I had a good faith basis for making the action. There's nothing else in Colorado law, even when you're examining the considerations a court is supposed to make when imposing sanctions in discovery actions. The case law, it's just to consider the parties' relative financial positions is also supposed to mean, how much do we apportion this so that it doesn't create a life-devastating impact on a plaintiff in this case,
Does that
attorney or
language
not.
appear in the statute? Is there language
Sorry?
in section 103 that states that in setting the amount of attorney's fees, the court needs to consider the bottom line impact on the party against whom the fees are being awarded?
Well, I don't recall that the statute says that precisely, but I do recall that in the cases that interpret it, that I've looked at over the years, that the intention of that is that, the American rule prevails here. This is a country that has already decided that just because you lose doesn't mean you pay the other side's attorney's fees.
But the statute's an exception to the.
There are statutory exceptions to it. I believe, Your Honors, that the purpose, as I recall, the purpose of Section 17C A0103 is to make sure that there isn't a disproportionate impact on the weighing. And first of all, Your Honors, the Colorado Supreme Court has made has commented on the importance of proportionality and expenses and things like that with respect to discovery. And for a case where there's approximately $6,000 at issue, to have another side run up fees and costs. The only reason it was in the district court at all was because that was what was required by the contract.
And you brought it in district court.
I was required by the contract. The contract that Mr. Bone drafted said that any enforcement action must be made in the district court. So if I believe that I'm enforcing the contract, I have to bring it in the district court. I thought that was stupid. This is one of the other things that I would have talked to Mr. Bone about had he bothered to communicate with me. And
Well,
that's the other
let me-
thing. There's a lot of things that
Ms.
happen.
Kazazian, let me just
Okay.
finish reading what the judge found with respect to the D that I was just mentioning. Plaintiff should have been aware, and the court finds that she was aware of the great deficiencies in her case and the consequent possibility of facing adverse costs and attorney fees judgments should she persist in asserting claims so lacking in factual and legal merit.
Yeah, I see that, Your Honor, but that is not what the standard is for this statute. The fact that in this case, the court made a determination of credibility and decided that the evidence I presented was unpersuasive. However, in the summary judgment motion, the court first said in the order that, going to the hearing was absurd, and then in the December 19th or 29th order recognized that it wasn't absurd, that there was a reasonable basis for that. So,
No, as I read the December 29th hearing, it wasn't that there was a reasonable basis for going, to court on the summary judgment thing. It was that you had defended against the award of fees on grounds that were not frivolous.
Your Honor, yes, my argument is that the same defense, those facts were not made in defense of the amount. Those facts were made in the defense of an award in particular.
Please finish your argument, Counsel.
Thank you. So I believe.
When I say finish your argument, I mean sum it up.
2 seconds, okay. So for the reasons stated in the briefs, I believe that I'm asking the court to vacate both of the judgments in the district court, to send the case back down to the district court for trial, to vacate the award of attorney's fees, and pursuant to CRS 5-102, to award plaintiff interest on the judgment that has already been paid. And I would also like to note that Mr. Bone's argument that the fact that judgment was paid should mean that this is waived is frivolous.
Your time is expired.
Okay, I'm done, Your Honors, I'm sorry.
Thank you.
I thank the panel for the questions.
Thank you. Mr. Bone.
Afternoon again, Your Honors. Michael Bone, B-O-H-N, with Bone Aguilar LLC, registration number 18716, appearing on behalf of the defendants, appellees slash cross appellants, GHP Horvath, PC, and Nadine Petrowski, one of its principals. Your Honors, and I appreciate Judge Daly's comment at the beginning of today's proceedings and your advisement. And I will do my best to stay within those confines, Your Honor, and
I appreciate it, counsel. I understand that terrorizing and misrepresentation, I think we're probably crossing the line that I had wanted, and I would ask you not to cross that line as well.
Yeah. Your Honor, we have outlined at length the claim for our attorney's fees, both in the trial court and in the Court of Appeals. And we are of the position that Ms. Kazazian's appeal to this court, both her appeal of the attorney's fees award and the court's underlying summary judgment award, to come to this court knowing full well that the judge has already said that your claims were frivolous, to come to this court and still argue about whether or not there was an enforceable agreement. We are of the opinion, we are of the position, and we have asserted at length in our briefs that my clients are entitled to an award of their reasonable attorney's fees as a result of having to do so.
And that's true, and that's in the other appeal. Now we're talking about the attorney fees award and lack of award, and the positions taken by the parties in this appeal.
Correct. And we are also of the opinion in this appeal and position in this appeal that Ms. Kazazian's appeal here contesting the reasonable attorney's fees that the trial court awarded is equally frivolous and groundless, for all of the reasons that we've set forth in our brief, and I won't beat those anymore. But Your Honors do have to understand the lengthy history here that I think does come through in the record and does come through in our briefs. We, my clients and I have been battling Ms. Kazazian since August of 2013. We are going on 6 years this August. We tried to resolve the small claims case, as I argued before in the prior proceeding. Ms. Kazazian did not accept it. Instead, she has brought another lawsuit in the district court, seeking to enforce an agreement that never was formed. That came at great expense to my clients. If you look at the record in this case, I understand that Ms. Kazazian is blaming us for those fees, but if you look at the record, we essentially filed two substantive motions, a motion for summary judgment and a motion to require cost bond. And I think these facts are important for the court to understand why the fees got to be what they were. And to be clear, to date, my clients have paid us in excess of $100,000 defending against these claims brought by Ms. Kazazian. The complaint that Ms. Kazazian filed in this case was signed under oath, under penalty of perjury. She said she was a resident of Sweden. As a resident of Sweden, we filed a motion to require her to post a cost bond under Colorado law. And after we filed that motion, Ms. Kazazian said, no, I didn't mean residents of Sweden for purposes of the cost bond statute. I meant it for voting purposes or something to that effect. We had to go through the expensive proceedings to try to determine exactly where her residency was. The trial court found, is in the record, he found specifically that Ms. Kazazian misrepresented her residency to the court.
Is that a focal part of this appeal in this case?
It is not the focal part of this appeal, but what is the focal part of this appeal is the abusive litigation conduct that we've experienced at the hands of Ms. Kazazian. And she is specifically contesting the fees in this case. And our argument here today is that the judge's determination of our fees was exactly correct. He just didn't award us enough. And I think it came through in our briefs quite clearly. The trial court, the Honorable Judge Buchanan, initially entered an order in October of 2017, and he gave us $27,000 approximately in fees. And because we were aware that Ms. Kazazian had filed an appeal,
27 or 17?
27,000 in the first, yes, the first order that
See, I
the trial
thought-
court entered was October 18th, 2017. It was the order regarding defendant's motion for attorney's fees. And the judge specifically awarded us $27,657.50.
But in the December 29th order, it's 17,000 something.
Yes, he took, what we understand the judge to do was basically, after we filed our motion for clarification and amendment, and essentially, what we were trying to do was save the trial court some work, save the appellate court some work. We know that Ms. Kazazian had appealed an attorney fee order in another case, setting forth these, arguing about these 103 factors. So we specifically filed a motion to clarify and amend the judgment and order, not only for that purpose, but also to remind the court that it certainly appeared he intended to award us 100% of our fees, and he awarded us 100% of our invoiced fees. But at the hearing, I had specifically testified, and we offered evidence that we had incurred approximately another $12,400 in attorney's fees, and those fees he hadn't awarded. So part of our motion to amend or clarify, we wanted to make sure he hadn't forgotten those, and then we addressed the 103 factors.
And
Well,
I'm sorry to interrupt.
certainly, Your
Mr.
Honor.
Bone, those additional 12,000 fees were for what?
Those were fees that were incurred at the attorney fee hearing and our efforts to try to get the attorney fee award.
Would you agree that Ms. Kazazian had some success on the attorney fee issue in that the district court didn't award your client all the fees that it had requested?
I would agree that well, I don't know why the trial court changed its decision and reduced the fees. Because, and this is what I was going to get in my argument today that we've outlined in our brief, Ms. Kazazian offered no evidence in support of any of her defenses against our attorney fee petition. So that's why we are arguing here today and have argued in our briefs that her defense to our attorney fee petition, excuse me, Your Honors, lacked substantial justification in that it was frivolous and groundless.
Didn't Judge Buchanan find that she had indeed had a defense to the attorney fees petition, both on entitlement as well as on amount of fees, with certain different factors he ticked off?
Your Honor, he did, and I guess the distinction that I'm making here is if you look at his order, and as we've outlined in our brief, he initially starts with saying there was some evidence, and then as he starts getting a little bit more loose with his language, he said, she appeared to argue, she argued, but he does not reference any specific evidence that she offered at the hearing, even though it consumed 2 days. There was never any evidence offered by her to defeat our fee petition, and specifically, she offered no evidence to support any of the defenses that she had initially raised in her written response to our fee petition.
Did she raise the block billing issue, or did the trial court raise that issue sua sponte?
Your Honor, I don't recall specifically, but I believe that Ms. Kazazian may have mentioned the block billing issue.
And the trial court reduced your fee request based on some block billing, right?
I believe in his second order, he didn't reduce the fee petition, he just said he couldn't make a determination based that we had lumped a couple things together. But I don't think he was penalizing us because we had engaged in block billing.
But if Ms. Kazazian raised the issue, and the court then didn't award you certain fees based on an argument that she presented, wouldn't that show that her argument had some merit?
I would agree with that, Your Honor.
Let me just read. The court cannot find that the defense of defendant's motion for attorney fees itself lacks substantial justification within the meaning of the statute.
Where are you reading that from, Your Honor?
That's on page 6
Of the December 29th order?
of the December 29th order. And it's
Page-
right in the middle of that large paragraph.
Okay. And I'm sorry, where were you again?
Well, it's in the middle of that large paragraph. And throughout that page, the judge is making the finding that the defense
Correct. I know where you're at.
Okay.
And this is the paragraph that I'm talking about, where he says, as well as her evidence at the hearing. But there was no evidence at the hearing, and that's the basis of our appeal. There was no evidence offered at the hearing for any of this. Well, let's just cut to the chase on this financial position of the parties. Ms. Kazazian evaded taking the stand at the hearing. She offered no evidence. She didn't take the stand and raise her hand and swear to tell the truth. She argued from the podium. She was never sworn in as a witness. And she claimed that she was financially destitute, for lack of a better term, and just argued these concepts to the court. But she did not take the stand. There was no evidence for the court to evaluate. We didn't offer any evidence of the financial position of the parties. She didn't offer any evidence of that.
Didn't she make an offer of proof at least?
Well, that's exactly the point, Your Honor. Yes, she made an offer of proof. She did make an offer of proof, but she didn't offer any evidence, and we didn't get any opportunity to cross-examine her on that, on those contentions, as the judge pointed out. He said, okay, I accept basically your offer of proof, and I assume, Mr. Bone, something to that effect, I assume you would cross-examine on all of these points that she raised, which absolutely we would have. But there was, what is the purpose of raising these defenses to an attorney fee petition in a case where the court has already ruled that the action and the complaint was frivolous and groundless? If we're not entitled to get our attorney's fees, the statute would have no teeth if that were the case. To not award us a single dime in connection with our efforts to get our attorney's fees, it would make absolutely no sense. And is it realistic? Is it possible that the attorney's fees that you are spending for the fee petition are going to exceed the underlying judgment? Absolutely, I'm here to tell you that, and your honors know that. Absolutely that can happen. But without a proper award, and especially under the circumstances here, and I can appreciate the law that says, well, you have to assess whether the defense was equally frivolous and groundless as well. And here it was. She put us through the ringer. She could have asked for her hearing, as we've outlined in the brief. She could have said, I want to put you to your proofs, and it's your burden to prove you're entitled to these attorney's fees. Fine. We could have showed up at the hearing. We would have called, I would have taken the stand. The hearing would have been over in an hour. As it was, given all these defenses that she raised and no evidence offered in support of those defenses, it consumed almost 2 full days. Well, maybe not quite 2 full days, but obviously that came at a great and significant expense, and the court didn't award us any attorney's fees on that. And again, as we've argued, and as I'm telling your honors here today, that's patently unfair. And all it's going to do is encourage more abusive litigation. If the statute doesn't allow you to recover those fees, then we're just wasting our time. People are going to file frivolous lawsuits all the time, and they're going to evaluate, well, they're going to raise this defense and say, well, your fees are absolutely unreasonable.
Hasn't the Supreme Court, though, rejected the idea that fees on fees are automatic out of a 13-17-102 case? Haven't they said that basically it's got to be lacking substantial justification? The defense against the fees must lack substantial justification itself?
Yes, that's what I'm referring to. Yes, that is exactly the rule. And that's why we're arguing here that, in fact, in this case, specifically, Ms. Kazazian did not have any evidence to defend against that. And I understand your honor's concern, and I know that long paragraph says something about evidence, but look at it closely and look at the record. There is no evidence in the record. The defense,
But she did present some legal arguments, like the argument on block billing that the court found reasonable, right?
that's correct. There might have been some of that, Your Honor, but for us to not be awarded anything in connection with our efforts to obtain fees on a case where the court had determined that it was groundless and frivolous, and...
Well, the court was persuaded by Defendant's Exhibit E, correct?
That is correct.
Let me ask you, counsel, the standard of review here is abuse of discretion. That's a tough one to overcome. How do you overcome that here?
Well, we overcome that here because I think it's patently unreasonable for the court not to award that. I think it's absolutely arbitrary. And in fact, the court was going to award us these fees and had awarded us the fees. And then when we filed the motion for clarification, he had he took away the fees that we had incurred trying to get our fees. So I understand the abuse of discretion standard, Your Honor. I know it's difficult. I'm asking Your Honors to take a look at it. I'm asking Your Honors not that you wouldn't do this. Please look at the record in this case. We have endured several years of this, and we're asking the court for an award of our attorney's fees, remand this case to the trial court for our appellate fees, or the evidence has already been offered and confirmed in the trial court, and this court could enter an
Thank you,
order
counsel.
for our fees. Thank you, Your Honors.
Thank you. Thank you both for your arguments. The case will stand submitted. I don't believe that counsel has any rebuttal time, does she? No? Okay. Thank you both for your arguments. The case will stand submitted. Opinions will issue in due course. Thank you both very much. Thank you.
Thank you, Your Honor.
Thank you. Welcome to Division 2. This is the 2:30 docket. We have one case on it, People versus, is it Canody, C-A-N-O-D-Y? How do you pronounce that?
Mr. Canody.
Canody. Thank you very much, Mr. Canody. We have just the one case on it. When you came in, you should have received oral argument procedures from the bailiff. Is that correct?
I'm familiar with them now.
Okay. Do you have any questions?
No, Your Honor.
Okay, you could stop popping up. I really appreciate it. Thank you very much for doing that. I do appreciate it, but you don't have to do it anymore. Remember, we are live streaming this argument. We're also archiving on our website. If there is sensitive or confidential information, please do not air it, such as minor victims, victims of sexual assaults, things like that. Please do not mention those names. With everybody in the audience, please turn off your pagers and your cell phones so as not to disrupt the argument. And when you come to the podium, give us your name and registration number. With that, I think we're pretty good. We can start.
Thank you, Your Honor. May it please the court, counsel, my name is Gail Johnson, registration number 29703, and I represent Menelaus Canody in this appeal from the denial of his motion to withdraw his guilty plea. I wanted to begin my remarks this afternoon, by just making clear that the posture we're in here is a motion that was filed before sentencing, and therefore the standard of a fair and just reason under Rule of Criminal Procedure 32D is the governing standard. I think that's important because after sentencing, Rule 32D is not available to a defendant to move to withdraw a plea, and the defendant's only option at that point is to file a motion under Rule 35C.
Counsel, when ineffective assistance of counsel is claimed as the basis of a 32D motion or a 35C motion, is there a difference in the standards? And if there are, what is the difference?
Absolutely, Your Honor. The way I would put it is this. The 32D standard of a fair and just reason for withdrawing a plea is a lower standard than the 35C standard to show a constitutional violation. So if one demonstrates either, for example, ineffective assistance of counsel or involuntariness of the plea, both of which are obviously constitutional violations, ipso facto, that would meet the lower standard of 32D. But it is not necessary to meet that higher standard in order to demonstrate a fair and just reason for withdrawing the plea.
Are you arguing something besides ineffective assistance of counsel here as the fair and just reason for why Mr. Canody's appeal should be granted?
Yes, Your Honor. I think the constitutional interests are raised as well as non-constitutional reasons. So the fair and just standard is what is being argued. And I realize that there's also discussion of the Strickland standard, but that's why I wanted to begin here, because I think it's so important.
But you're saying the Strickland standard doesn't apply.
I'm not saying that. I'm saying, let me do this a better way. I think if this court looks perhaps at the Crum case, or it might be Chippewa, you'll see, the court doesn't need to decide the constitutional questions when there is a fair and just reason for withdrawing the plea under 32D. And I think the appellate courts in our state often avoid the constitutional questions they don't need to decide. So to be sure,
Sorry to interrupt, Ms. Johnson. How would you apply, if I'm looking at Crum right here, how would you, it doesn't seem to address ineffective. How would the Strickland ineffective be looked at under a fair and just reason?
well, I think what Crum says is that there's a non-exhaustive list.
Right.
There's a non-exhaustive list of factors. And it talks about, the third factor there is whether justice will be subverted if the motion is denied. The court in Crum goes on to then say, here are some examples of when justice may be subverted. One example is when a plea is entered through fear. One example is when a plea is entered through fraud.
Sorry to interrupt again. A plea entered through fear, how would that look? Is that what we're talking about in this case?
Yes, because the record is undisputed that Mr. Canody found himself in a position where he had maintained his innocence, told his lawyer 20 or more times, I'm innocent, I don't want to take a plea to something I didn't do, have you done the investigation? And repeatedly she came back and hadn't done any investigation.
Counsel, I'm sorry. Was this the argument made in the district court below that it was a plea entered in fear as opposed to ineffective assistance?
It was both. And the fear also encompassed his concern about the children, his inability to have access to the children, and that a court could interfere with that. And so then there's other case law that says, another possible fair and just reason would be, of course, if your plea was unconstitutional. But I'm simply suggesting to the court today that we do not need to reach the constitutional question. Again, to be sure, if we meet that standard, we meet the 32D standard. I think it's important, so to sum up, here we are presented with a case where, here's the question. If the defendant maintains his innocence and pleads guilty only because he feels pressured and fearful, because he thinks his only options are to take this plea deal or go to trial with a lawyer who's inexperienced, has never tried a sex assault case before, is not sure if she's ever even pled one or handled one, and has not conducted any investigation to support a defense at trial, is that a fair and just reason to allow him to withdraw his plea?
If an investigation had been conducted, what facts helpful to the defense does the record show the investigation would have come up with?
So that is not in the record, but it's not required to be in the record under this standard, because the question, even under the constitutional question for withdrawing a plea, the standard is whether there's a reasonable probability that absent counsel's errors, the defendant would have rejected the plea and gone to trial. And I think that's abundantly demonstrated here. And that's why it's so important to focus on the difference between 32D and 35C. To be sure, if this were post-sentencing, only in the 35C context, that would be a different standard and a higher one.
Yeah, counsel, I was going to say, what was an investigation supposed to turn up beyond the idea that the victim had asserted that this was a sexual assault, and I believe the defendant had said it was a consensual sex. And so what, besides knowing what the victim was going to say and what the defendant was going to say, would an investigation have picked up?
Oh, Your Honor, there are myriad types of information that could come to benefit a defendant from criminal defense investigation in a sex assault case. Could be information about inconsistent statements by the alleged victim. It could be information that otherwise impugns her credibility. It could be reputation or opinion evidence. It could be variances in her statements to her brothers. And again, it could be a history of lying. I mean, without the investigation, you don't know. And that is why there is such a strong duty imposed not only by the Constitution, but by the ABA standards on defense counsel to investigate a case. And what the Colorado Supreme Court said in People versus White back in, I think, 1973 is, you can't do your job as defense counsel unless you investigate a case.
Are there any types of sexual assault cases where an investigation would not be necessary? Or is one required in every single case before the defendant can intelligently make a plea?
Your Honor, I'm having a hard time thinking of one where it would not be necessary. Again, under the ABA standards, they're very clear that such investigation is required regardless of the prosecution's evidence and regardless of the statements of the defendant.
Counsel, was People versus White brought to the district court's attention below? Do you know? And it's not controlling. I just wonder whether or not the district court had a chance to consider People versus White.
Your Honor, off the top of my head, I don't remember if it was cited in the motion, but I can check that.
No, that's fine. You don't need to. We'll check it. Thank you.
I mentioned a moment ago the two ABA standards. I don't think there's any dispute, and perhaps the court could ask Mr. Lee today, but I don't think there's any dispute that Ms. Casey violated standard 4.41, the duty to investigate, and standard 4.4-6.1 regarding how investigation and plea bargaining play out. And we have two cases, the Crum case and the Chippewa case, both of which partially rely on these violations by trial counsel, violations of these ABA standards, to find that there is a fair and just reason for withdrawing a plea.
What was the second, Chippewa and Crum, did you say?
Crum. This is a very unusual record. We have Ms. Casey, the trial attorney's own testimony at the evidentiary hearing. This is January 26, 2018, page 19, lines 18 through 20. She says, quote, "There certainly are plenty of people that plead guilty to things they did not do. And I didn't want that to. I felt that Mr. Canody felt in his heart that that's what he was doing," end quote. So I think the district court here abused its discretion by overlooking Ms. Casey's view that Mr. Canody had pleaded guilty to a crime he believed he was innocent of. And she had advised him to do that, even though she had utterly failed in her duty to investigate the accuser's allegations.
But didn't he tell the trial court that he was satisfied with his attorney's representation of him at the time that he pled guilty?
Your Honor, he did successfully go through a Rule 11 colloquy, which
Yes.
does include that question. But I would make 2 points in response to that question, Your Honor. One is, even the district court during the Rule 11 colloquy perceived and commented on the record about Mr. Canody's reluctance. That's the word the district court used, and the court mentioned that he heard that reluctance in Mr. Canody's voice, so he kind of took a step back. But also, I think the broader point here as a policy matter and as a legal matter, a successful or an adequate Rule 11 colloquy cannot be sufficient to deny a defendant the ability to withdraw his plea under Rule 32D, because if that were the case, then no one would ever be able to withdraw their plea, right? The premise is that someone has successfully gone through a Rule 11 colloquy. If I may reserve my remaining time for rebuttal. Thank you.
Thank you, and may it please the court. John Lee on behalf of the people, bar number 38141. I'll begin where defense counsel did, because I don't think their proposed governing standard sufficiently grapples both with the controlling law and the actual posture of this case. So while it is true that the issue in a Crim P 32D case is whether there is a fair and just reason for withdrawing the plea, that's the standard that applies when the trial court makes a decision. That's not our posture here. The issue on appeal is whether or not, having made that decision, whether the trial court abused its discretion in finding that the defendant did not present a fair or just reason for withdrawing the guilty plea. And to piggyback from this court's earlier case, abuse of discretion is a hard standard to meet, and defendants unable to make it in this case. The defendant essentially raised two arguments in this case as to why he should be allowed to withdraw his plea. The first one is essentially a voluntariness claim. He believed that his attorney had provided insufficient investigation, and because of that, and also because he mistakenly believed he couldn't fire his attorney and be appointed another attorney, he pled guilty.
Does the state concede here there was no investigation conducted, and that if there was no investigation, there was a violation of the ABA standards?
The record does provide that no investigation was done. There was a little bit, the trial court did find some quarrel as to whether or not an investigator was sent out to contact the independent witness. Defense counsel did not remember her files, had deleted some files, and she said that if it wasn't her file, she wouldn't affirmatively say whether or not that had been done. But we do not concede the legal point, which is that that would have been a violation of ABA standards, and more importantly, that would have been an adequate investigation. There is a difference between an attorney who evaluates the facts, looks at a case like this, and decides that investigation would not be a reasonable avenue and that her time would be better spent pursuing a plea agreement. So long as that is a knowing decision and it's reasonable given the facts of the case, that's not deficient performance.
Why would it have been reasonable in this case?
It is a he said, she said case, as defense counsel pointed out in the trial. It was a sex assault that happened in the defendant's apartment. There was no evidence presented that there was any other avenues that defense counsel could have pursued that would have changed it from being a he said, she said case.
But what if the victim had made inconsistent statements to third parties, and those statements could have been discovered through some type of investigation?
And if you look at the transcript, I do think counsel did consider that possibility, but yet still decided that pursuing a plea was stronger. In her testimony, she does describe that even if this case was unlike other cases where you had a sex assault victim who either had recanted or didn't want to proceed with the prosecution, and based on her knowledge of cases like this, even though this was one of her early cases, that in those cases, either the victim would in fact testify that the defendant was guilty, and that even if she was to recant, she would just be impeached with the statement she gave both to her brothers and to the police. So I do think that was considered in this case, and as a result, performance was not deficient.
Mr. Lee,
Did the court make any findings on the deficiency of performance?
Not express. It concentrated more on whether or not it in fact induced the defendant's guilty plea. Most of its findings, at least on this prong, was more related to the fact that the defendant's guilty plea was in fact knowing and intelligent and voluntary, which was based on the Rule 11 and the court's very thorough explanation to the defendant during the provincy hearing.
so let me ask, if it's in a discretionary standard in looking at the Crum factors, non-exclusive list of factors, the Supreme Court stated to determine whether the defendant has shown a fair and just reason, we consider, so the appellate court considers whether, quote, a plea was entered through fear. So does this case fall within that umbrella? And how do we know if it was a plea entered through fear, if that's a factor that the appellate court should consider?
It certainly is a factor this court consider. It's one that the trial court rejected, and I think with record support. The record shows that the defendant didn't plead guilty because he was afraid. I think the argument below...
But my question about, I assume a lot of pleas are entered because of fear, but is this getting at fear because of an ineffective, my attorney didn't do much investigation, if any? That's a different kind of fear than somebody going to prison as a result of a plea or going to trial.
Yeah, and I think that kind of gets at the crux of the issue is what the defendant would have needed to show, and that is in fact his burden, is that if not for this alleged lack of investigation, had the attorney done what she was supposed to do, the proceedings would have been different. And in order to show that, there would have needed to have been some evidence that she could have uncovered something that would have changed the outcome of trial, which in turn would have been for him to turn down the plea and why he would have wanted to pursue a trial.
In People versus White, they didn't talk about that type of prejudice, did they? How would you distinguish this case from, say, People versus White?
I would say for the same reason I would distinguish all the cases that the defendant cites in the reply brief. In all of those cases, the 3 Colorado cases and the 4 out-of-state cases, you have something specifically told to defense counsel with precision that would have been a material defense. It was more than speculation. And in this case, we only have, at best, speculation. So to go through those cases, in White, for example, if I'm remembering correctly, that was a case where the defendant told his attorney that all of the items he was alleged to have stolen, he either purchased or traded for. And he told his attorney, if you talk to those witnesses, they'll all tell you that. The attorney didn't do that. So in that case, you have a very specific, here are these witnesses, go talk to them, I'll tell you who they are, and this is the defense it will lead. Same thing in Herrera. In Herrera, it was a case of an aggravated robbery. Defense counsel was told that the defendant's theory of defense was alibi, that there were witnesses and given a picture of people who would have confirmed that the defendant was in Minneapolis at the time at a family party during the aggravated robbery. That was even more important in that case because the only witness the defense did have, although she said he was in Minneapolis, couldn't remember the date.
Sorry to interrupt, what was the theory of defense here?
That's the
would it
issue, and
have
I think
gone to
that's
trial?
why they failed to meet their burden. They never explained what further investigation could have done, how it wouldn't have just been a he said, she said case. Because, I mean, certainly every defendant wishes the attorney could find some defense that would result in an acquittal, guilty or not guilty. I mean, every defendant wants
But
that.
had Mr. Canody asked his attorney to interview specific witnesses, which is similar to the situation in the cases that you cited, for example, didn't he request that his attorney speak with the brothers of the victim?
Not in that it wouldn't have elicited a different theory than what counsel is already aware of. So in this case, there is no dispute that counsel told the defendant, and I do think it's important to point out, there's no indication in the record that she wasn't willing to go to trial under the he said, she said defense. So although there were witnesses identified, that wouldn't have changed the theory or counsel's decision that the defendant would have been better off, and her time would have been better spent, trying to procure, which was, I think, indisputably, a very favorable plea deal, rather than run the risk of going to trial and facing a he said, she said case. Given what the attorney knew at the time, which of course is the standard that we look at. So in addition to that, as this court's case in Boiling makes clear, and Supreme Court's cases in Martinez, because it's abuse of discretion standard, if there's any record support for the trial court's decision, it should be affirmed. In this case, we do have the Rule 11. I take defense counsel's argument, I mean, that can't swallow the rule. That's true, but it doesn't for trial courts, because nothing about that rule prevents a trial court from finding whether there's a just reason for withdrawal of the plea. But on appeal, it's a different question. And in this case, and especially with the record we have here, the defendant specifically stated at the time he entered his guilty plea that he was satisfied with his attorney. It's directly in the Rule 11 that he was satisfied with his attorney for all critical stages.
But doesn't the defendant make that statement in every single Rule 11 colloquy?
It does, but I mean, and that's for a purpose. That's because, again, it's such a big deal to enter a guilty plea because the defendant waives all rights, including the right to present a defense, that we want to make sure that the thing is knowing and voluntary, and that's why it's in every Rule 11.
Yeah, but there may have been reason to call it into question when the defendant at the 32D hearing is saying kind of like, I didn't want to plead, I was innocent, and my lawyer even says, you're right, he didn't want to plead, he said he was innocent. So there may be some reason to call into question whether he was truly satisfied or not. You started to mention something, counsel, before when there was a question about was this plea induced by fear? And you said, well, the court said it was not induced for fear because of what?
Oh, the court found it was knowing and intelligent. So it wasn't that the defendant, the court basically found that the defendant's, it was a change of heart rather than the defendant didn't enter into his plea knowingly, voluntarily. So at the time the plea was entered.
I got that. Knowingly, voluntarily, but out of fear. What did the court say specifically to say it wasn't based on fear?
It pointed to the very specific providency hearing where if this court looks, again, in addition to the Rule 11 and the general advisement, on page 7 of the providency hearing, the court in this case went one step further than normally does and said, defendant, are you sure you want to plead guilty? I just want to be clear. Is there anything? Are you absolutely sure that you want to enter a plea of guilty and it's your choice? And the defendant said yes.
And that's because of the reluctance. At the providency hearing, the
Yes,
judge
well-
said there's reluctance, right?
But that doesn't change the fact that at the time the defendant made his plea, that there needs to be a nexus between what the alleged fear or fraud or whatever between the time the defendant made his plea, not that there's a good reason after the fact as to why he'd want to withdraw his plea. I mean, again, a trial court could find there could be a just reason based on something that's not tied to it, but I think in order for this court to find an abuse of discretion, it would have to say that the trial court's finding that the defendant, at the time he made his plea, that he wanted to plead guilty and it was his choice and it wasn't due to any misrepresentations from his counsel, that's completely unsupported by the record. In this case, it is supported by the record. And I also think it's completely supported, even if we go further with the test, that again, this case is completely different than the other cases the defendant cites. And I guess I would point to the Thai case that they cite from the Kentucky Supreme Court, where it cites just how objective the test needs to be. If a defendant's trying to withdraw a plea based on his counsel's failure to investigate, there still needs to be a nexus to show that the defendant would have not pled guilty if but for that alleged deficient performance. Would there have been a defense, and would that defense have likely to prevail at trial? Because only then would it have been likely the defendant wouldn't have pled guilty.
Likely to prevail at trial, I don't think that's going to be the test for prejudice for entering a plea of guilty. I think the test for ineffective assistance prejudice is whether or not the person would have gone to trial, not whether he would have prevailed at trial.
I will say that is exactly what they said, the Kentucky Supreme Court said in Teague, which is the case the defendant cites. They said that was a tantamount standard. And I will say, I think it makes sense to me in why would you go to trial and turn down a very favorable plea if you don't think you're going to win at trial? So there is, I think, a logical connection between the two standards, because why would you plead guilty if you don't have a legitimate defense at trial? And especially in this case, when you face a very hefty sentence and you're offered an extremely favorable plea deal. So the two standards, I think, are related. And in this case, even apart from that, the record fully supports the trial court's findings. It heard evidence. It found that the defendant's plea was voluntarily intelligent at the time, and that although he had changed his mind, it wouldn't have subverted justice, which is the standard that this court stated in Jones as being the standard, to deny the defendant's motion to withdraw his plea. Just briefly, in addition, even beyond that, as we pointed out in the brief, a court can also deny a motion to withdraw a guilty plea with prejudice to the prosecution. In this case, as the prosecutor pointed out to the trial court, beyond just the delay and the need to get ready for trial, this case presented unique prejudice in that the prosecutor had to convince the victim in this case, who was reluctant to allow the plea deal, to offer the plea deal, and it would cause extreme prejudice to the people then to have to go back and tell the victim that they were wrong and that it would in fact have to go to trial, and the defendant had decided not to take the plea deal that she had reluctantly agreed to in the first place.
The question of prejudice doesn't come in, though, until after you've determined whether there's a fair and just reason to allow the plea to be withdrawn, does it?
Nope. So, and again, I think this court certainly should, and that's pretty much how I wrote the brief, should deny it on the front end. But this is in addition to. So even if this court were to find there was a fair and just reason, nonetheless, it should be denied based on the prejudice to the prosecution. If the court has no further questions, I ask you to affirm. Thank you very much.
Your Honor, to follow up on the court's specific question about whether the People v. White case was brought to the attention of the district court, yes, it was. That's found at court file page 105 in the written motion to withdraw the plea, paragraph 17, specifically on the failure to investigate. Investigating a case and pursuing a plea bargain are not either or propositions. And what the Colorado Supreme Court teaches in White is that the one is necessary to do an adequate job in negotiating the other. There's abundant concrete evidence here that Mr. Canody made specific requests, as Judge Lipinski acknowledged, specific requests for specific investigation, interviewing the accuser, interviewing the brothers, interviewing the people endorsed by the prosecution and listed in discovery. None of that was done. That's not in dispute. And I spoke before about the White case, about that sort of cascading level of duties, but I'd also direct the court's attention at page 72 of that case. The Colorado Supreme Court emphasizes plea bargaining is a legitimate means for disposing of criminal cases, but it may not be utilized to subvert the truth or as a means of forcing a plea to an uncommitted crime. This might have been a wonderful plea bargain for somebody who was guilty of the Class 2 felony of forcible sexual assault. It's a terrible plea bargain for someone who maintains his innocence. The court was discussing with Mr. Lee about what was the nature of the district court's ruling on fear and how the district court approached that. And I would direct the court's attention to that transcript, which is, I believe, July 26, 2018, page 64, particularly lines 15 through 18. The district court says, I can't base a decision as to this motion on what Mr. Canody says he believed or what he thought might have happened. End quote, and there's a little more there, but he says, what I need to base it on is the record, what was stated, what he signed, what the Rule 11 provides. I think that's the encapsulation right there of the abuse of discretion. Of course he can base it on what Mr. Canody subjectively believed and Mr. Canody's subjective fear and Mr. Canody's eminently reasonable perception, abundantly supported by the record here, that he only had two options. Go to trial with a lawyer who refused to investigate, apparently, because he's asked her 20 or more times to do so and she's not doing it, or take this plea bargain. Those were what reasonably appeared to him to be his only options. And so again, for the district court to just sort of rely on, well, we had a successful Rule 11 colloquy, that's an abuse of discretion, because again, that would swallow the rule. If the court has no further questions, I would ask this court to reverse. Thank you.
Thank you, counsel. Thank you for your arguments. Thank both of you for your arguments. It'll be very helpful to us in disposing of this case. The case will stand submitted. Opinion will issue in due course. With that, business of the court is concluded today. The court will stand in recess, subject to call, and the bailiffs shall announce.